Hi, folks. This is Gail Pendleton. I'm Executive Director of Assista, and we welcome you to one of our series of new webinars and trainings on topics for those of you working with survivors of domestic and sexual violence and other crimes who may be encountering or will be encountering possible attempts to remove your client. So we want to help you build your skill set, and we can tell, looking at who's in attendance, that some of you may already be doing this. So I will, during the presentation, be asking you some questions about whether there's anything you want to share. With us today, we are very glad to have Maria Baldini Poterman, who's the founder and the attorney at Maria Baldini Poterman and Associates. And you're in Chicago, right, Maria?
Correct.
And then we've got Professor Jeff Hoffman, who's the director of the University of Lawson Hughes Center Immigration Clinic, obviously, in Houston. Okay, let's get started, Alam. Next slide. So the goals of this are pretty basic. This is not gonna, you can't in 2 hours teach you everything you need to know about going to federal court, but we're hoping that after you attend this, you'll at least be able to identify possible federal court options for you applicants. We're gonna focus on U's, by the way, but a lot of this will apply to VAWAs, and feel free to ask questions about that. That you'll be able to identify the next steps you need to take to pursue those options, which you'll see is mostly like logistical things you need to pursue, things you may need to learn more about. And finally, who else you need to work with and what else you need to learn. And this is where we would definitely like your feedback for future trainings on how to take this further and how we can help you learn what you need to do to work with survivors. Okay, next slide, please, Anam. Oh, and while she's doing that, for those of you who haven't done one of these webinars with us before, take a look at your control panel. There's a drop down that says questions. You want to click on it so that the arrow is pointing down, and that's where you can send us questions. And you should send us any kind of question you have. I particularly want to hear any clarifying questions, so I can introduce those during the presentation. I may also ask you to wait until the end, but I will be paying attention to what you're sending in. And if it's a question I know the answer to, which seems highly unlikely given the topics here, I can answer you directly. So the things we're going to review, discuss today are mandamus, habeas, Administrative Procedures Act, and declaratory judgments, federal question statutory challenges, and petitions for review. Next slide, please. So I think, Maria, you're going to take us through the beginning of this, right? And we're going to come back to this at the end, but I think up front we wanted to let people know that there are some, I'm calling them logistical, but basically not related to like legal arguments, things that you need to do to be able to appear in federal district court. So one of the things you mentioned, Maria, is that some district courts actually have their own training videos or other kinds of trainings that people who want to appear before them have to take before they can. Can you tell us about that?
Sure, thanks, Gail. So each district court gets to make up its own procedural rules for admission, and one of the formats that the district courts have gone to in the last few years is to require that attorneys who wish to be admitted actually have to complete either an in-person training or an online training about how to file through the PACER system. PACER is a password-protected system where attorneys will file the initial complaints or other documentation, and then it will be docketed by the court clerk and assigned to a judge. So this is something that you need to look into now rather than later. The district courts will schedule certain times, and it may be once a month, it might be once a week, for training so that the person can then be given a password and access to the online system for filing. Another issue that comes up as well is what it takes to be admitted into a particular district court. So in order to even do the application, you typically need to get certificates of good standing from each state in which you are licensed to practice. As different groups and parts of the state bars have moved to online filings or requests, there are some that still require the mail-in route with a check and your request for the certificate of good standing. those can take anywhere from 2 days up to 10 days to process and then be put in the mail to you. So again, this is something that takes some thinking ahead in order to get the certificates to then be able to fill out the application and submit it.
And who do you ask, who gives you the certificates? Your local bar organization?
No, it's actually the part of the court system in your particular state that issues you your license. So here in Illinois, I ask what's called the Illinois Attorney Registration and Disciplinary Commission to issue my certificate of good standing. I'm also barred in Minnesota. There, I actually go to the Minnesota Supreme Court, and an office within the Supreme Court then issues my certificate of good standing.
And just to clarify another thing you mentioned, so let's say I actually am barred to practice in 3 different states. If all I want to do is actually file a lawsuit in a Massachusetts federal district court, do I only need to get the certificate for that court, or do I need to get it from all of the states where I can practice?
That is dependent upon what the district court requires for admission.
All right, so this goes back to your point that every district's different, basically, right?
It is, and something that I learned the hard way when I wanted to file a habeas petition down in Louisiana about 2 years ago is that Louisiana has a special rule. So you have to hold a license from Louisiana, and you also have to have a physical office in Louisiana in order to be admitted to practice in the district court in Louisiana. So there may be restrictions, and you might have to hire local counsel to appear on your behalf while you apply for pro hoc vice, or a one-time admission for a single case. And again, this is something you need to look ahead and figure out where your clients are at. Are you admitted, or someone else in your practice or your nonprofit has been admitted, so that if you need to go in on an emergency basis, then you will be able to do so. As far as local counsel goes, many of the district courts require that a person who's already been admitted to practice in front of that particular federal district court fill out paperwork on your behalf saying that you're a good person, they've known you for so many years, and be a local sponsor. Other district courts also now are asking for new attorneys to be mentored by local counsel or by more experienced attorneys. So it's in your interest to find out what the district court procedures will be and what is required to be admitted, or to make the connections sooner rather than later in the event that you do need to file a habeas or another type of relief in federal district court.
And again, where would you find that? Can you, like, do you just put in your local district court name and go to their website, or how do you find out this information?
So you can just Google, for example, the U.S. District Court for the Northern District of Illinois, or the U.S. District Court for the Southern District of Texas. And the information then will be on the web page. It's usually under a link called Attorneys or Procedures.
Great. Perfect. Okay, terrific. You ready?
Let me just add.
Oh, go, Jeff.
Let me just add, Gail. So the Maria is exactly right, and I agree with everything she said. Just with respect to the pro hac vice admissions, that can be pending when you file your complaint or your habeas petition. So just be aware that if you do have local counsel and they're on the complaint, then you can put your name, pro hac vice application pending, and then that can be done later on after the complaint is actually filed. And I've done that before. And I also echo Maria's point about getting the certificates of good standing from all of the various jurisdictions, which could also include circuit courts and other district courts, not just state bars.
Okay, great. So we had discussed ahead of time that we think it'd be great to come up with some samples of things. It seems like the pro hac vice is another sample we need to put together for folks so they can see how that works. Okay, are we ready to move on? Yeah. Next slide. Great. So here's a hypo so we can work through some of the ways you may want to go to federal court with your U visa cases in particular. Emma has an approved U visa, which is based on domestic violence. She filed an application for her derivative, Lavinia, who has not yet been approved, although you responded to an RFE in Lavinia's case over a year ago. So, Maria, we'll start with you. Is there anything, and if the audience wants to answer this through the questions box, feel free. Is there anything you could file in federal court to get CIS off its butt to decide Lavinia's application?
Well, let's give it a minute and see if we have any answers coming in on the questions box. Or a few seconds, I should say. I don't see any. So what you could file in federal court is what's called a mandamus action. A mandamus action is asking the court to order the USCIS to do its job. And basically, it's to make a decision about the application for the derivative. So where the request for evidence has been pending for more than a year, the first thing that you need to do is to look at what are the processing times for that request for evidence. And then the second thing that you would want to do is also see how far beyond the processing time this petition has been pending, or this application has been pending. You can also put in a request through the Vermont Service Hotline for an adjudication if it's beyond the posted processing times. What the district court cannot do is order the USCIS to grant the application. It can only order it to do its job, which is to adjudicate the application.
Let's move on there. Let's move on to the next slide, Alon, where we can start getting into the, okay, you already told us a little bit of this. So that the key point with mandamus is that you're not, or one of the key points, as I understand it, is you're not asking the judge to actually make a ruling on the law itself. You're asking the judge to just make the government take action one way or the other. Is that correct?
Correct.
Okay. Okay, so then let's go to the next slide, Alon. So an example of where we've been doing this already, and it's now kind of moving out of the mandamus phase, frankly, was trying to get CIS to issue bona fide work authorizations, which was added to the statute in 214P6 a while back. And that's some of the examples you'll see in your materials is a mandamus that was filed by Stephen, why am I blanking on his name? Anyway.
Steve Manning.
Stephen Manning, yes.
Yeah.
Closely with him, blanking on it. And it's an example of, you can see there that it's basically, it kind of goes to what you're saying, Maria, about the processing times. The argument's a little different, but it sounds like the argument you have to make is, you know, Mike, this is something you're not doing that you're supposed to be doing. And I guess you would rely on their failure to follow their own processing times for Lavinia. And you have to make a decision one way or another based on the law, or what you're saying. And so the reason I'm not using this as the example anymore is that it seems like CIS may be wanting to take this to court and actually litigate whether they have to implement the bona fide standard at all. But we have seen people, the reason I use Lavinia context is we have seen people trying to do this with cases that have been sitting around a long time. And I'm now, if you are asking me for technical assistance, you may see me suggesting that you consider mandamus if that's the issue that you're experiencing, because basically we have no way to communicate with CIS anymore. I can send them stuff, but they won't reply. And as far as I can tell, they're not actually acting on anything I'm sending them. And I've frankly kind of given up on the system reviewing itself adequately. Although we'll get to what you have to do to set things up for federal court within the system in a few minutes. So shall we move on?
Gail?
Yes, Jeff, go for it.
If I may interject, this is Jeff. The mandamus complaint has to do three things. It must establish, one, that the plaintiff has a clear right to the relief requested. Number two, the defendant has a clear duty to perform the act in question. And number three, that there's no other adequate remedy available. So I think it's important. I think we've provided to the audience the practice advisory from March 2017 from the AIC, American Immigration Council.
Yes.
And I would just, and I know we're going to get more into jurisdiction, et cetera, in a minute, but I would just point everybody to the statute, which is 28 USC 1361. the three elements that I just covered. And also on that practice advisory, there's a really helpful list of factors to determine when the delay is unreasonable. It's on page 7. And of course, we can do that in more detail, but I just wanted to set that up right now.
Okay, so repeat, and Alam, could you move the slide to the next slide? We're going to get into the basic federal court concepts, but repeat again what you said, Jeffrey, about the 3 things that you want to establish for this.
Well, so just since we're talking about mandamus, I just want to set it up, at this point that there's something called the Mandamus Act, which is 28 USC 1361. And take a look, everybody should take a look after this webinar at the practice advisory from AIC, which discusses mandamus actions avoiding dismissals and proving the case. And also be aware that, again, there's 3 prerequisites that you must establish to bring a mandamus. He or she has a clear right to relief requested. The defendant, which is CIS usually, has a clear duty to perform the act. And number 3, there are no other adequate remedies available. And just be aware that the government a lot of times tries to say that they don't have a duty or that they've done as much as they need to do, and therefore they don't need to adjudicate the case at this time. So they will push back on you, and we can talk about some of the defenses that CIS and DHS will raise and the statutory bars. But again, I just wanted to lay that out up front.
Very good. So I put all that in the chat, and we will definitely add them to the next time we do this. So, Maria, do you want to come back and review some of the basic federal court concepts before we move into other kinds of relief and discuss the various options?
Sure, we can do that. And I think we're also going to later on get a little bit more into the different points that have to be proven. So in drafting any type of complaint to file with the district court, you have to establish that the court has jurisdiction or the power to decide the issue. You also have to establish that you are filing in the correct federal district court, which is known as venue. You have to determine who are the parties to this complaint or this lawsuit, which can be, of course, your client, and then who it is you're suing on the other side, on the government. And you have to demonstrate that you've exhausted administrative remedies. So starting with jurisdiction, that is what are the elements of the law that you are going to cite. And if we can move to the next slide. So the sources of law first have to start with the statutes. Then you move into the regulations, other agency memoranda, and finally the Constitution. So as Judge Easterbrook and Judge Posner here in the 7th Circuit like to routinely remind immigration practitioners, they don't want to hear or see the constitutional complaint up front. You need to start with the statute. What are the statutes that give the court the power or the jurisdiction to decide the matter? After that, regulations are created by agencies to interpret what the statutes say. So sometimes you can challenge a regulation as being ultra vires or beyond what the actual law says. That can be one source to challenge. As we all know, EOIR and DHS run on a lot of memoranda. So there's, quote, law that we have to follow or that the agencies are supposed to follow that are in memos that constantly change, but those are also sources of law. And then finally, the Constitution, which the 5th Amendment has the due process clause, the 4th Amendment has improper searches and seizures. And those 2 provisions are the ones that we most commonly will include in our complaint.
So let's work this through with Lavinia's mandamus. What would be the sources of law, or what could we creatively say the sources of law are for our argument that they should adjudicate her a long delayed claim?
Okay, so as Jeff mentioned earlier, the mandamus statute itself, which is the one where the court can order the agency to do its job, that's 28 USC 1361. Another common statute that we include in just about every filing is 28 USC 1331, which is on the next slide. And that has to do with the federal question. So whenever there is a lawsuit brought in federal district court, the district court has original jurisdiction over all civil actions arising under the Constitution, laws, or treaties of the U.S. So original jurisdiction means that you can file that lawsuit initially in the district court. You don't have to file a lawsuit someplace else and then move to bring it to the district court or appeal to the district court. The court has the first jurisdiction or the first shot at this lawsuit. So treaties are part of the U.S. law itself. And so at times there might be an issue where you bring a treaty, but in a mandamus action, that's not going to be relevant. So the important point off of this slide, which Alam, if you could move it to the next one, that would be great, is that you should include the federal question citation in your jurisdictional statement. Another issue that comes up is where to sue. And venue, a civil case, is really an important concept. So the plaintiff can file suit where the plaintiff is located. If it is a federal government agency, you can sue where that agency is located. So this is the one time where, and this is different than habeas, which Jeff is going to talk about a little later, you actually have the opportunity to sue in your home court where your client's located, or if you're suing the Vermont Service Center, you would sue where the Vermont Service Center is located in Vermont. So there's different considerations to be taken into account.
And can I just interject a little bit on the work authorization mandamus? We had people try both. So there were several people who, they basically threatened to sue in Vermont. The AUSA made CIS grant work authorization. And then similarly, some people tried in other district courts. And up until now, that's been the reaction. Now they're saying they want to go to court on it.
As far as who the parties are, it's obviously going to be your client as the plaintiff. And then who you name would include the CIS director for the Vermont Service Center. I typically would name the head of the USCIS and also the director of DHS, or the head of DHS. When we get to talking about habeas, though, we're going to have a different discussion, because there, who you sue is critical, and you can't necessarily name everybody up the line. And then exhaustion of administrative remedies, the fourth point on some common concepts. The district courts don't want to be bothered until you've demonstrated that you've done everything that you could with the agency. So when we're looking at filing a mandamus, we want to make sure, at least here in the Northern District of Illinois, that I've submitted 2 or 3 different status inquiries 3 months apart to demonstrate that not only are they beyond processing time for whatever application it is, but also that I haven't gotten a satisfactory response because the petition or the application has still not been adjudicated. I will also typically send an email over to the Assistant U.S. Attorney in charge of the immigration cases saying, hey, here's my string of requests for status inquiries. These are the responses I got, which is a boilerplate letter, or if I got no response, I then put in that I got no response. Would you like to reach out to the agency because I'm getting ready to file a lawsuit in the district court? So you want to just make sure you've got that paper trail, and that at least where I practice, it's been at least 6 months of inquiries to show that you've taken what you can do with the agency before you go in and ask the district court to act.
Okay, so hold on one second, because I think I need to be able to control the slides, Alam, and I don't think you can see my chat. Is there a way you can make it so I can control the slides? I would like to be able to go back and forth as we cover the different concepts. Okay, so that goes to what you just said, goes to one of the questions that came in, I think, and let me make sure I'm understanding it right, was, for instance, let's say your argument is it's been a long delay. How would you decide what delay is long enough to justify filing a mandamus?
Gail, I'm making you the presenter. Sorry to interject, okay?
Yes, please. Thanks. That'd be great.
Do you, Gail, can I make a point?
Yes, please.
On the, I see a bunch of, okay, I'm not sure what I'm seeing here. Okay. I just wanted to make a point just to follow up on Maria's excellent point about exhaustion. And then I'll move to the other issue. But on exhaustion, what I like to do too, in addition to having 6 months of proof that you followed up with the agency, is I like to send what's called a mandamus warning letter. And the mandamus warning letter can be sent to the district director of the USCIS office that has jurisdiction over that application, and basically give them 30 days or 60 days. Sometimes I give them 60 days, and then say after that period of time you'll take all appropriate federal court action. And I like to do that because I can attach that to my complaint, and that's sort of like a final warning. And as Maria said, you can also forward that to the U.S. Attorney's Office before you file the complaint, or with a copy of the draft complaint.
Okay, and so it sounds that is what people were doing with the work authorization mandamus, and that's their response was to grant the work authorization to those threats. But now I think we're going to have to go through with actually filing things. So both of you, how would you argue? It sounds like exhaustion of remedies might be one of the issues for things where they've issued an RFE and you've responded, but they haven't replied for over a year. How would you argue? So what would your argument be that's, I guess you would look at, that's why you said, Maria, look at their own processing times. And if you can argue it's outside their processing times, that would be the argument that you've exhausted your remedies as far as you can for that.
Correct.
Okay.
I would add, yeah, I'm sorry, Maria, go ahead. You good?
I'm good. Go ahead,
I would add that remember I mentioned the factors that go into reasonableness mentioned in the practice advisory. Take a look at those, because it says the timetable or other indication of the speed which the agency expects to proceed, the delays that might be reasonable in the sphere of economic regulation are less tolerable when health and welfare are at stake. Number 4, the court should consider the effect of expediting delayed action on agency activities that are of higher or competing priorities. Number 5, the court should take into account the nature and extent of the interest prejudiced by the delay. And number 6, the court need not find any impropriety lurking behind the agency's delay. In other words, it's not just the processing times, but the courts are going to take a multi-pronged approach and determine whether, under the rule of reason, it makes sense, weighing all these factors for the agency to take so long. And also, we should mention, I know we're going to cover the APA, but the APA has its own unreasonable delay provision, so they may be violating the APA, not just the Mandamus Act.
All right, great. Okay, Maria, did you have any other thoughts on how Lavinia's case would fit in these common concepts that you think they all need to think about?
Just on administrative remedies, it's helpful if you talk with other local practitioners. And AILA does publish minutes from local liaison meetings with USCIS. So there's also published minutes from the liaison meetings with the Vermont Service Center that are available. In some instances, you may want to consider adding the responses as part of the complaint to demonstrate that it's no longer reasonable that the agency is going to actually act without an order from the court.
Great. And someone's asking, do you need to have a stay to file a mandamus? It would seem like in Lavinia's case, you couldn't, because they're not trying to remove her yet, right?
Right. There's no requirement for a stay of deportation. If that's the question? There's no requirement for like an I-246 administrative stay from ICE. There's no requirement as a prerequisite for mandamus.
Okay, great. So do either of you have any other thoughts on the sources of law that one could argue for a mandamus in Lavinia's case? You mentioned the statutes.
Well, I think the most important thing is that it's as Maria said, it's going to be 1331, 1361, which is mandamus. It's going to be APA, And the APA has a specific section, I think it's 555, that relates to delay. And also, we'll cover the other sections in a minute. And then, like Maria said, other sources that could be used that are not really, may not be statutory, but may be binding on the service. If there is any regulatory or memoranda or policy memoranda that talks about processing times, I would also cite those in the complaint.
And I'm sorry, I'm typing at the same time, so I apologize for those of you who can hear that. The APA also brings in constitutional issues, right? Because it's basically you're arguing they're violating due process, procedural due process. Is that correct, or am I wrong on that?
I mean, you can bring a Fifth Amendment claim because the due process is being violated, but remember, for Fifth Amendment purposes, you have to show substantial prejudice, at least in the Fifth Circuit. So you'd have to have some prejudice, yeah.
Okay, so you could have the APA. Go ahead.
You have to show a deprivation of liberty as well. And so different circuits have held that where you have a discretionary benefit that you're seeking, such as a waiver or other form of relief that is discretionary, that there is no judicial review of that. So you may encounter in the district court a reluctance as well to recognize a due process claim if there's no due process right in the actual relief. And so I think for mandamus, it's a lot cleaner if you cite the statute for mandamus and the INA sections that apply, as well as the Administrative Procedures Act, but not necessarily on a mandamus for like a U visa, a Fifth Amendment right.
Okay, that's very helpful. I just happen to like the Constitution, so. Okay, let's move on. And people, if you have questions, I mean, we're going to come back to these things as we go through the different federal court possibilities. So, but please, so, as you can see, for those of you who are asking, if you're asking a very specific question, I'm asking you to raise it again later, or a procedural question. Let's
if I could just add one more thing, Gail, really quickly on this. On a mandamus, if your client has an outstanding order of deportation in their record, you might want to take some time to really talk through with them if they want to go forward and sue. And I'm saying that just because we are in the enforcement era now, and we're not under the Obama administration. So while the 2010 Morton memo for victims and witnesses is still officially in play, there's nothing to say that it might not be in another month, as we've seen this administration take away almost all the prosecutorial discretion memos and strike them.
Well, and also, I mean, even before the change in administration, they were often using the, the exceptions to swallow the rule. So I think that's a very good point, and that one of the paradigm shifts that we've been talking about is that nowadays you need to be careful about who you contact in the system, including CIS, because that may raise red flags for people who want to go after your client for other reasons.
I just want to say, responding also to that point, and I think it is an excellent point, that it's not just people who have orders of deportation. So before I go to federal court, I'm very, very careful about the underlying basis for the application. Because again, if you're going to go to federal court and, potentially put your client on the stand and subject them to cross-examination by a U.S. attorney, if there's any sort of problems with how they entered the United States, or their underlying refugee status, or their underlying U visa application, or their marriage allegations of fraud, again, you want to make sure that the case is not going to create more problems for them. So I would only recommend mandamus if it was a case with a clear, a clear duty on the part of the government to adjudicate that case, and doesn't have any of these extraneous or debilitating factors.
Right, and again, we are here to help you with that. I think I'm sucking in some litigators to help us mentor you on these cases, but also help us understand what the best advice is to give on this. So this is just the beginning. We'll definitely have Jeff and Maria and others helping us out with your individual case questions. Okay, so did you want to, I think you already kind of covered this, Jeff, the federal question statute, but do you want to, is there anything else you want to say about this? Whoops.
In terms of 1331?
Yeah.
Well, 1331 is important because there are other types of challenges that you can do, not just the mandamus, not just APA. It underlies also statutory challenges, as Maria said, based on violations of the INA. So again, it gives you the justification or the power to go to federal court and to try to seek remedies of violations of the INA more generally. It also allows you to go to federal court if there is a pattern in practice that the agency is engaging in that violates federal law. So obviously, it's going to be the most important, most essential jurisdictional hook that you're going to use, and it's not limited to mandamus or other actions.
All right, that's very helpful. So then let's go to where, in my view, the rubber hits the road, which is what is it you're actually asking them to do? This seems fairly straightforward with mandamus, right? Maria, do you want to finish this up for mandamus and then we'll move into habeas?
Sure. What you're asking the federal district court on a mandamus to do is to order the agency to adjudicate the application. That's all really you can get out of a mandamus. Sometimes as part of the order, the court may order the government to provide a timeline on when it anticipates it will have that adjudicated. Then you'll go back to another hearing, and then the court, if it's not been adjudicated by then, will then issue a definite date by which the agency needs to act.
Ah,
interesting. Okay, great. Okay,
and let me just add, I had a mandamus that got resolved, but it got resolved when the service provided a new interview for my client. So sometimes they'll agree to an interview, and then the interview will address certain issues, and then the court will say that that's sufficient for mandamus. But obviously you want an adjudication in your favor. But if you don't know whether an adjudication in your favor is going to happen, then you might just be satisfied with a new interview and allow your client to present the case, because then at least it's moving forward. So I just want to make that point.
Great, that's very helpful. So what the government can do to abide by an order may be different depending on the case, is one thing you're suggesting. Okay, so, and here we're going to come back to EJA later on, but I think we want to flag for you right now that if you're doing this, one of the new things you might want to start thinking about if you haven't done any federal court work is the Equal Access to Justice Act reasonable attorney's fees and related costs. And that we are suggesting, I think, right, presenters, that should be a regular, just like all those other jurisdictional things we were talking, this should be a regular prayer for relief if you're doing these cases.
It should be, and just a note here, as soon as you start working on the complaint, you need to track your time. And the typical standard that I've seen the courts want to have is increments of 6 minutes or 0.1s for an hour. So you need to track it up front and not go back and try to recreate it later, because the court on an EJA petition eventually is going to look at what is the amount of time spent on this particular issue reasonable. And the courts are not in favor of paying attorneys to go do basic background research about mandamus. Mm-hmm. So track your time, track a separate entry for the same day if all you're doing is reading about mandamus and learning about the law. And that may end up going to your office time or your research time, but it doesn't appear on what you submit to the court. So do be careful in tracking time up front.
Okay, so that's very helpful, and I think we will come back to this at the end with more detail, but we did include an AIC/National Immigration Project advisory on this. It sounds like a sample that would be worth us doing as an example of how people track their time who do this on a regular basis. Okay, so meanwhile, ICE has picked up Lavinia because they did a raid on her neighborhood and she was hanging out with the other kids on the corner, and ICE just picked up everyone who didn't have documents on them. You asked ICE to request that prima facie determination from Vermont, which their memos say they should do, and we included the memos in your materials, which Vermont said yes to the prima facie, but then they refused to expedite. Is there anything you could do now in federal court, Jeff, to get Lavinia out of detention and, you know, put some barriers into her, it's really a her, removal, while you're waiting for them to make a final decision on this?
Well, if you're saying that she is in detention, then of course you can always ask for a bond hearing, you know, before the IJ, and then, you know, habeas corpus would come in if for some reason the judge found that she was not subject to bond, or the judge found she was subject to conditions of confinement that you found overly restrictive. So, you know, I can start talking about the habeas, and also as part of the habeas.
Okay, wait. But before you go forward on that, Jeff, so just
Sure.
so I understand it, so could the government argue that you have to request bond to exhaust your remedies?
If you're talking about a habeas, yes.
Okay, so the people need to at least, even if it's futile, make a request for bond before they file a habeas, it sounds like. Okay.
Correct. Now, there may be what's called a matter of Joseph hearing, and I know that you know, when we were preparing for this, we talked about this. So the matter of Joseph is a hearing, as you know, that deals with a ruling on the part of the IJ on the status of the individual. For example, could be various issues. It could be the status as an arriving alien, or the status as an aggravated felon, or whatever it may be. And of course, as you know, those determinations are really, really important, because if somebody's found to be an arriving alien, then they're not subject to bond. So you see what I'm saying? So once the IJ makes that decision, then if you disagree with it, you would then try to take appeal to the Board of Immigration Appeal, and at the same time you could go to a federal court, because you would argue that the appeal would be futile. But technically, you're right. You have to at least try with the IJ first, and then go to the federal court on a habeas.
So basically, you're saying there's an exception on this exhaustion of asking for a bond where they can't grant a bond, basically.
Well, you would challenge the determination in federal court on that threshold issue. Yes.
Okay. All right. And I know we're coming back to matter of Joseph later, so maybe that will help clarify this a bit. But there's always exceptions to everything, is what this may be one example. Okay. Good. All right. So tell us a bit about habeas.
Okay. Well, habeas obviously is a you know, very, very important part of our jurisprudence, and it is something that is guaranteed by the U.S. Constitution. The suspension clause of the U.S. Constitution provides that the privilege of habeas corpus shall not be suspended unless in cases of rebellion or invasion to public safety. That's Article 1, Section 9, Clause 2. There's a statute, 28 U.S.C. 2241, as it shows on the screen, that says that habeas can be granted by Supreme Court justice or any district or circuit judge, although practically you go to district court. The habeas cannot extend to anybody who's in custody unless, number one, they're in custody under or by color of a law, color of authority. I don't know why that says 3, but he is in custody in violation of the Constitution or laws of treaties of the U.S.
So, and in this case, prisoner includes people held in immigration detention, it sounds like.
Correct, because it's custody, even though it's civil custody, it's custody under color of authority, and it's detention by ICE or by the federal government.
All right, great. Okay, I think I skipped the constitutional site, but there's the constitutional site. It's in your materials. Okay, and then we have the Real ID Act, which adds a gloss, I believe.
Yeah, so in 2005, the Real ID Act came out, and there was a lot of misinformation. I remember when I was practicing in 2005, I remember a bunch of people saying, there's no more habeas, there's no more habeas. And so that was actually not true. But what the Real ID Act did say was that there is no more habeas to challenge the final orders of removal in district court. So again, that's going to be, if you want to challenge the final orders of removal, you have to wait till there's a final order from the BIA, and then you're going to take it up through a petition for review, which we can mention later and discuss later. And what the Real ID Act says, it's INA section 242, says that the circuit courts of appeal have the exclusive or sole jurisdiction with respect to final orders. But as we know, habeas review does exist over challenges to detention or conditions of confinement that are independent of the challenges to the final removal orders.
Right. So it sounds like that's not going to be a big barrier for us because we're going to mostly be challenging other things. But it's worth realizing that, because really when you're challenging a final order, you're often challenging the basis for denying the merits. And so that's why you need to go up through the system.
Correct. And one more note I want to add is that it's not just waiting for the BIA to make a decision. Under INA section 238B as in boy, the ICE office can actually issue a final administrative removal order to anyone who is not a permanent resident, a refugee, or an asylee, and who has been convicted of an aggravated felony offense. So in this particular instance, the person does not have a right to a 240 removal proceeding before an immigration judge. So,
okay, I'm sending this out to the audience, but so just to review, the 240 means it's a full proceeding in front of an immigration judge. 238B was what you were citing. That's a way that they can remove people without a full 240 hearing?
Correct, if they've been convicted or allegedly convicted of an aggravated felony.
That's an administrative removal. I like to call it's administrative removal versus judicial removal. And Maria's exactly right. That's another situation where you can bring a petition for review. The third way you can bring a petition for review is through actually reinstatement.
Right.
If they try to reinstate you, you can actually get review of that in front of the circuit court.
Okay, so that's interesting. So even if it's not a 240 removal, you still have to go to circuit court to challenge an attempt to enforce an administrative removal, sounds like.
Right, and even an order from the BIA is an administrative removal order. It's not a judicial order because the BIA is not a judicial branch. It's not part of the Article 3 courts.
Okay.
Correct, but it's an immigration judge's, it emanates from the immigration judge. When I teach this, I like to, because I teach crimmigration, so I distinguish between administrative removal, expedited removal, and judicial removal. But Maria's exactly right. It's not an Article 3 judge.
Okay, so we call them administrative, but they're treated like final orders, not administrative orders, right? Okay. All righty, so petitions for review, speaking of which. So these are when you've got a final order or you need the merits reviewed. And why is this important for us to know about if we want to go to federal district court? Jeff?
So petitions for review, I think any discussion of federal courts, and I'm sure Maria agrees, you really have to discuss a little bit about petitions for review so that you understand, you know, they have to be filed and received by the court. So it's received by, not just mailbox rule, right? No later than 30 days after the date of the decision. If we're talking about a BIA case, it's 30 days after the decision from the BIA. This is a jurisdictional rule. It's not subject to tolling. It's not extended. This is important too. It's not extended by filing a motion to reopen or a motion to reconsider. It's not extended by the grant of voluntary departure. Another point is that ICE can deport an individual before the 30-day deadline to file the petition for review. And the filing of the petition for review does not stay or stop the physical removal necessarily.
Okay, so no automatic stay. All right, so it sounds like this may be, you may need to be combining this plus something in district court if it looks like ICE picks them up before the 30-day, where you may want to do a habeas or something like that, right?
Well, yes, you could do that. The problem is, I mean, I was involved with a case that happened recently where it was a DACA person, documented individual who was picked up, and the attorneys, I was involved with the Fifth Circuit, but the attorneys did go to habeas. They filed a habeas, but then the case was transferred to the Fifth Circuit. So if the district court doesn't feel that that's the appropriate venue or location, then they might just transfer the whole case to another venue. But yeah, you might want a multi-pronged approach. And the other point is the stay can also be brought at the same time that you file the application for stay, at the same time you file the PFR. You can also ask for a stay.
Wait. Okay, before you go on, so PFR is petition for review. When you say file a stay, with whom are you filing the stay if you're doing it with a PFR?
Correct. So you're filing a motion for stay of removal, and that's with the Fifth Circuit or the circuit court, whatever circuit court, at the same time as you file the petition. That is possible. But please note that just by filing that motion does not stay the physical deportation of the client.
You need to have a decision. Okay, great. I'm kind of taking notes and sending them out through chat for those of you who aren't paying attention. Great. Okay, so that's
Another thing. Yeah, one other thing. This is circuit by circuit. So if your circuit requires you file the I-246 with ICE first,
Right.
and either ICE adjudicates it or there's not enough time, then you can file the emergency stay. But this really is like a circuit by circuit thing as far as administrative exhaustion before you file a stay motion. Here in the Seventh Circuit, if our client is physically in custody, we just go straight to the circuit and we file the emergency stay.
That's correct. That's correct. And also let me add that in the Ninth Circuit, I believe, I've done this before, that the Ninth Circuit has a different rule, right? That if you file the PFR, I think that it does stay it. At least that's my recommendation.
You have to file a one-page notice that you are seeking a stay, and then they give you 10 days to file the full stay request.
Correct. And during that interim time, it is stayed once you file the notice, correct?
Yes.
That's my understanding. Yeah.
So pulling out the teaching point here is that it's not going to be the same. Every court you're dealing with, and this goes back to you got to figure out what your court's rules are. Okay, is there anything different about jurisdiction here that for circuit courts that we haven't addressed? And what about filing to preserve issues?
Well, let me just say about that. So the issue, this comes up, for example, it gets a little complicated, but I have a case right now actually where there's a remand from the board. And so the question is, do you want to take a PFR to the Fifth Circuit or whatever circuit in order to preserve the issue that was not remanded? Does that make sense?
Oh, yeah.
So you have a BIA decision, they remand it for some issue. They think, for example, the person's eligible for some type of relief, so they remand it. But at the same time, they say to your client in the BIA decision, hey, wait a minute, we are going to deny the fact that you're a U.S. citizen, or we're going to deny the fact that you're eligible for asylum, but we'll remand for withholding. So you better file that PFR, because if you don't, then guess what? You've waived it.
Wow. Okay.
And so that's the issue, when to file preserve issues. The other point about preserving the issue is you can file a motion for reconsideration or a motion to reopen and then still take a PFR on the adjudication of those motions. I would recommend first filing the PFR on the final order and then also taking the motion to reopen or motion to reconsider at the same time, and then also filing a PFR after the board adjudicates that motion, because under INA section 242, then whatever PFRs you file have got to be consolidated once they reach the circuit court.
Okay, and when you're saying you'd file, so basically if the board is handling your, and so I think for those of you listening, I think this is most likely to come up with VAWA cancellation cases, and unfortunately I think you're going to be getting more of those as they pick up your VAWA clients. So it sounds like what you're saying is that there may be several times or several ways that you're going to be asking the circuit court to review the various contents of the board's decision, including, so the one thing I wanted to clarify is when you said reviewing their motions, do you mean like reviewing purely whether they did the right thing with the motion or whether the content of the motion?
No, you're talking about a PFR based on a motion to reconsider or reopen.
Right.
No, they'll review that is a situation where they will review the merits of those motions.
Okay.
Of course, with a caveat that INA Section 242, you have to read it really carefully, because there's certain issues that the Fifth Circuit or whatever circuit you're in is prevented by statute from reviewing. So again, I think we have another slide on that, but I could talk about what those issues are, those jurisdictional bars, if you want.
Okay, so is this it? No.
No, that's not it. So maybe I'll just let me just briefly say for the PFRs. So
Okay.
for a PFR, other practice pointers, just be aware as a practice pointer, the Circuit Court of Appeal under INA Section 242 is generally not going to review a discretionary decision. What do we mean by discretionary decisions? We mean, for example, whether something was balanced correctly in the discretion of the IJ, like a 212H waiver, criminal waiver, or 212I waiver, or even a cancellation of removal or adjustment if you're just seeking review of discretion. So that's not going to work. The exception to that is asylum, because 242 specifically says the court retains jurisdiction to review the asylum determination, even though asylum technically is discretionary. So there are other things we can talk about, but I would just say make sure that you're really familiar with 242 before you bring the petition for review.
And I think we can come back to this question of discretion versus legal content when we talk about the D14 waiver that we want to litigate near the end of the webinar. So.
Yeah.
Okay, so let's review some of the case law on the habeas.
Okay. Well, going back to the habeas, so habeas are great for constitutional challenges, especially for indefinite detention cases. So obviously, if somebody has been detained after a final order, that's the Zydvitas case. And I teach these three cases when I do my immigration class. But indefinite detention means that the person has been held more than 6 months. That's the rule of thumb after the final order, because then after that point, it kind of becomes punitive in nature, and obviously the Immigration Customs Enforcement is not executing the order. If you can show that there's no foreseeable likelihood of execution of that final order, then you should be able to get a bond hearing under Zydvitas. And that's a 2001 decision. Clark versus Martinez in 2005 extended it to people who have grounds of inadmissibility, not just deportability. So Zydvitas was a deportable individual, and Clark versus Martinez was an inadmissible person. And then mandatory detention, there was a constitutional challenge to, as you know, INA Section 236 provides for the categories of somebody who's mandatory detention. And in that case, Mr. Kim was a lawful permanent resident, and he was subject to mandatory detention. And he said, well, as a lawful permanent resident, I think I should get a bond hearing, and I should not be subject to mandatory detention. So he took a habeas challenge, and what the Supreme Court said was, yes, you can go to court on a habeas, but they also determined that mandatory detention during the pendency of removal proceedings is constitutional. So he won in a sense, but he lost the overall case. But he did win in the sense that you can bring a constitutional challenge to mandatory detention.
But having said this, this doesn't mean these are the only contexts in which you can challenge the detention. You could challenge, like,
Right.
picking up a U or a VAWA, even if they're not subjected to indefinite detention, they haven't been in for 6 months or whatever, right?
If they're not given a bond hearing, or, like, for example, I'll give you a good example. So I had a case in Miami where I used to work, and when I was in private practice, that dealt with somebody who was who was being detained, and we asked for an ankle bracelet. We asked for ISAP, intensive supervision, and the judge said that he would not give ISAP and did not have the authority to grant that alternatives to detention. So we actually took it to federal court and won in the Southern District of Florida in a habeas case, because we argued that that was an incorrect statement of the regulations and the statute. And the federal district judge held that he could basically provide conditions that would not be detention in the facility, but would be conditions on an ankle bracelet.
Which seems like a good segue into this slide about what does in custody actually mean. Does it mean
Right.
someone has to be physically detained? It sounds like
It sounds like,
but it's not true, right?
It sounds like it should be physically detained, but actually in custody could mean that you have restraints on your movement, like an ankle bracelet, or even that you have an order of supervision and you have to check in, or even if you're subject to a final order and you're subject to check-ins, you can actually go to federal court if you think that those conditions are too restrictive, and try to get those ameliorated. So yes, that also is a possible habeas challenge.
Okay, that's very helpful. All right, let's see what our next slide is. So let's go back and apply what we went through in terms of the general concepts to this habeas. So what we talked about in the mandamus was there were, well, let's do with the parties first, right? And as I understand, this is particularly important for habeas because if you fail to mention the right parties, you can be thrown out of court.
Yeah, I mean the parties. Maria can talk about the circuit split, but the parties basically in a detention-related habeas case, you really want to name the warden of the facility because the government has argued that the warden is the proper party, the proper respondent in a petition for writ of habeas. That was in a case called Rumsfeld versus Padilla. And so, again, you can name other parties. For example, I would name the Department of Homeland Security, the DHS Secretary, the Office of DRO, Detention and Removal Operations, the Field Office Director, the ICE officer in charge, the ICE facility, detention facility, or whatever facility it is, as well as the Attorney General. But Maria can talk about different circuit splits on that, I think.
So this is where you need to look at your circuit law. Here in the Seventh Circuit, I lost a case called Koyaski versus H.M. And the Seventh Circuit held that it was the warden who must be named first as the actual holder of the person's body. And that is who you name. In addition, though, I do name the Chicago ICE Field Office Director because that is the person who commands the warden up in Wisconsin to hold the client, or down in Southern Illinois to hold the client. In the Sixth Circuit, there you name the ICE Field Office Director and then you put the warden second. So because of this, you really do have to look at your circuit law and make sure you name the correct leading party for that circuit.
So they're that picky, huh? It's like they care who is listed first, not that they're just on the list, huh? That's scary.
Correct, and not even though ICE in the local field office is the one who's making the call about where to place that person. I do also name DHS headquarters in DC, and then if it's a pre-order challenge, I do name the Attorney General because the immigration judges fall under the Attorney General. If it's a post-custody order, I typically do not name the Attorney General because it's a post-order case. So pre and post removal order is also an issue you need to consider. The other issue that often comes up here is when ICE decides to move your client specifically out of that district court's jurisdiction. So I have seen motions by U.S. attorneys moving to dismiss the case once ICE decides to move them out of a favorable district court that actually has a clear processing time for deciding habeases and moving them, say, to Southern Illinois or moving them to Louisiana. And I don't have an office in Louisiana and I'm not barred in Louisiana.
Yeah.
So these are considerations that you need to look at as well. Talk to other practitioners and figure out how fast a case is going to proceed get your habeas on file without necessarily giving the government a heads up that you're going to file, so that they don't move your client to a less favorable district court.
Let me just mention that we didn't have it on the slide, but a related issue, I mean, it's very related, but it's a different issue, is that it's not just the parties, but it's service on the parties. And I can tell you through experience that that's very complicated sometimes. So in the practice advisory that we have in the materials, I think it's called Whom to Sue and Whom to Serve. Take a look at page 6, because it really lists and explains the federal rules of civil procedure that relate to who to serve and how to serve the summons and complaint.
Okay, so
And not
just
only
back to
that,
what-
but summons is one of the more tricky issues, and you do need to deal directly with the district court on the summons.
So back to your point about them moving people around to basically avoid having to deal with your habeas. Once that, let's say you file it in your sympathetic district court, once the judge actually assumes jurisdiction, can ICE still do that successfully, or will the judge retain the case?
My experience with habeas has been split on that particular issue, Gail. At
Okay.
times, district courts have dismissed it because the body is no longer within the jurisdiction to order them to court, to bring the body to court. Jeff, what has your experience been?
My experience with moving people around to avoid that, the jurisdiction of the district court.
Yeah.
To be honest, I really haven't had that situation with respect to a habeas. I've had that situation with respect to removal proceedings, where they they removed my client to Arizona when he was in Miami,
Right.
which made it very difficult to adjudicate to pursue the relief. But I think the answer, what I would just say is, if it started in one jurisdiction and the government is engaging in that type of behavior, I think that the federal judge would entertain a motion to compel the government to either bring him back or to allow the case to be transferred. So I think that's something that you could get the federal judge involved in and really police that with ICE. That would be my answer.
Right, because you'd think they'd not be happy that they're basically trying to do an end run around the judge.
Correct.
Anything new, anything we have discussed already in terms of the jurisdictional bases? Or venue, for that matter? And it seems like administrative remedies exhaustion for these would be that either a stay. So back to that earlier question, this is where you might want to show you've tried to file a stay or not. It sounds like the problem with doing that.
No, I wouldn't say stay. I would say, I think you mean a bond hearing.
Well, no, actually I meant a stay to ICE, but it sounds like that's dangerous because then they'll be on notice that they maybe should move your client to a different jurisdiction. So.
Well, no, there's no prerequisite of filing an I-246, for example.
Okay,
so no, I wouldn't say that. But there is exhaustion of remedies. So if you run to federal court and say I want my client released, the first thing that the habeas judge is going to say is, well, did you ask ICE to release him or her? And that also is not just ICE, but also DOJ. So did you file a motion for bond?
Okay.
But I think the point that you're making also is a good one, because you can ask the federal judge then to stay deportation proceedings in the context of a habeas. So maybe, I guess I see where you're going with that. Maybe if you ask the federal judge to stay in the context of a habeas, if there's some sort of imminent deportation, the federal judge might ask you, have you filed an I-246? So yeah, I think that may be a possibility, but it's not a hard and fast
requirement. So we could have, if ICE had picked up Lavinia, even if Lavinia had never asked for a stay, you could still go to district court and try to, because they've got her in custody, right?
Well, and we talked about this too in preparing for this. You could always do an emergency TRO. If the person, for example, is being put on a plane, you could try, and you can't reach ICE, you could always go to federal court and on an emergency basis and seek a TRO, and that can even be done ex parte. It's very, very, very unusual, and you could get in trouble if you do it without bases, and I would not recommend it. but it is possible to seek a stay on an emergency basis with the federal court.
Right, and this is something that I've been confused as I learned this, is that often you will do a preliminary injunction temporary restraining order request not as part of the habeas, but in addition to the habeas.
Correct.
Okay, so now let's go back and review a little bit, again, running through that, just focusing on the habeas. So are there any different sources of law for habeas that we haven't discussed already, that we want to cite in Lavinia's case?
Well, the habeas statute is 2241. You know, the regs that relate to detention are in 8 CFR. The policies relate to, you know, may relate to the policy on arriving aliens, could relate to the policy on releasing people under certain circumstances that DHS has different guidance memoranda. It could relate to policies about mandatory detention. So, and I think the Fifth Circuit here, I mean, not the Fifth Circuit, the Fifth Amendment here would be the constitutional bases.
Okay, and then so what about, would this be one place where we could start raising, for instance, let's say ICE had refused or hadn't done the prima facie request to Vermont, we could still use the memos and say they're not following their own process, Your Honor.
You mean DHS, right?
Yes, right. If
Yeah.
DHS is not following its own policies that haven't been rescinded yet officially on how they treat victims and are just going around picking them up and not doing what they're supposed to do, this would be an example of a policy you could argue as a source of law.
Well, I think that would be another cause of action that would be a violation of the INA
Okay.
or their own procedures. And yes, I mean, you can bring that as an additional cause of action that's in addition to the habeas. And it may also be an APA claim that you could tack on. So you're not limited in any way to the number of causes of action that you want to bring in your complaint.
Great. Okay, that's helpful. Okay,
Gail,
so
for one
yes.
more second.
Sure.
So I think that part of the confusion in looking at some of the questions that are coming in might be the difference between going to habeas and a pre-final removal order and a post-final removal order context. So
Okay.
just to be clear, if an immigration judge finds that an individual or non-citizen is subject to mandatory detention under 236C and there is no final order yet, you file an appeal with the Board of Immigration Appeals, but because you're claiming it's in violation of the Constitution, you can then immediately also go to federal district court on a habeas. And one of the things that the federal district court can do is order the Board of Immigration Appeals to make an expedited decision on the appeal. The district court can also order that another bond hearing take place or actually conduct the bond hearing itself. So there's no need to wait for the BIA appeal to be done if the immigration judge has already determined the judge has no jurisdiction to grant bond because that person falls under 236C.
Correct.
That's
Yeah.
great. And then there was a follow-up question, I think, to something you had said, Jeff. Lauren wants to know, how could you use a habeas to challenge like an order of supervision? I guess it would be the conditions of the order of supervision or the order of supervision generally.
Yeah, so if the order of supervision, for example, I had an ISAP case where the person had to have a very restrictive check-in period, for example. Let's say they had to check in, you know, a couple times a week, or they had to, you know, they were limited in terms of their ability to go to work, or whatever the reason is, you think that order of supervision is onerous and violates your client's rights, then you can attack that in a habeas.
And
So,
is
yeah.
the underlying theme that it's a restraint on liberty, basically? That's why it makes
Exactly. Yeah. Exactly.
Sorry, Marie, were you going to add something there?
Nope, I'm good. Thanks.
Okay, great. All righty. Good job. And so the prayer for relief we've kind of discussed. Does anyone in the audience want to throw these up, or it looks like we should just move along and have you guys do it. It's very helpful having you send questions, folks. So we discussed some of them, obviously. Release from detention. It sounds like you also want to do the bond hearing, the request for a bond hearing, and part of backing up is that that may be part of the exhaustion of remedies, that you've already tried to do that unsuccessfully, right?
Right.
Challenging conditions of confinement. Are there anything, examples of that you haven't already covered? There's the bracelets, there's the orders of supervision, like for instance, requiring them to come in every 2 weeks or something. You could argue, would that be a condition of confinement for purposes of challenging it? Or are you talking
Yeah,
about?
I mean, I could think of other. I mean, just to add, since you asked, there's other possibilities. So, for example, somebody is subject to, and we've had this with our LGBT community, if they're subject to segregation, solitary confinement, if somebody is, let's say, on an ankle bracelet and they're pregnant, and they're not taking the ankle bracelet off, that's been a situation we've seen where people have obviously medical issues that actually will result in harm to the person's leg because their ankles are swelling. I mean, there are plenty of conditions of confinement that you could think about. And then the clarifying other legal issues is what I was talking about earlier in terms of the decision on the part of the immigration judge that this person is subject to 236C. That's a legal issue that you can ask for a declaratory judgment on in habeas proceedings.
Okay, James, you're asking a couple questions that I think I'd rather come back to at the end, and we can put them all together and see if we can cover them. And did you just cover, does it stop removal, Jeff?
We covered that already, but I mean, the answer is it does not stop a removal. And this kind of goes back to, you know, Maria's point about whether it's pre-final order or post-final order. But again, you can apply for a stay with the federal court, and that is a possibility. It's not a prerequisite.
Okay, and so is the stay part of the habeas, or is it part of this preliminary injunction TRO, or is that one of the?
It's a separate. I mean, of course, you could put it as a prayer for relief, of course, in your petition for writ of habeas corpus, but
Okay.
I would actually do a separate motion for stay,
Okay.
and I would do that separately. But of course, you could also put it as part of your motion for preliminary injunction, in addition to the memorandum of law supporting the preliminary injunction / TRO.
Okay, great.
And I think I provided samples. So for everybody, if they want to have samples, we have those in the materials.
Excellent. Okay, so and that's a good segue into a little more about the preliminary injunction temporary restraining order. So as you mentioned, it's emergency and temporary relief. We discussed whether a stay is part of that. Let's come back to this matter of Joseph hearing explanation, which you just earlier, but you want to revisit it here in the context of this?
Yeah, I mean, matter of Joseph is, so in the old days, there was a case called matter of Joseph where ICE was trying to argue that the immigration judge should not decide or redetermine a determination by ICE that the person was, for example, an aggravated felon. They would say, look, we made that decision, so that's why he's mandatory detention. That's not within the jurisdiction of the immigration judge. It went up on appeal, and the Board of Immigration Appeals in matter of Joseph said, no, the immigration judge does have that threshold decision-making power. And so, again, if there's a matter of Joseph hearing, it could be aggravated felony, it could be whether a person's an arriving alien, whether a person entered EWI, or whatever, and you disagree with that decision, you can take that to federal court. And as Maria just said, you should also exhaust administrative remedies by filing an appeal, but you don't have to wait for the administrative appeal before the board. You can also go to federal court to challenge that determination by the IJ.
So that's helpful, because I think that goes to one of James's larger questions is, but if you wait until after the board makes a decision, your client may already be deported, right?
Well, theoretically, the board's going to make a decision on detention before there's a final order. But yeah, there may be emergency circumstances where you have to go to federal court. If they're, I've had situations where, we're worried that the person's going to be literally put on the tarmac and taken and placed on a plane. Then yes, you should exhaust. You should not have to exhaust, right? You should go to federal court and try to stop the deportation.
So
And
as a practical matter, the board routinely sits on the bond appeals and waits until after the merits appeal is decided and then issues a decision saying that the bond appeal is now moot. So there is a good argument to go forward with the habeas as soon as you've filed your notice of appeal with the BIA if it's on a constitutional challenge to 236C.
Correct.
And is that kind of a futility argument, or based on the board practice? Okay, great.
Correct.
The board can't constitutional issues that are substantive. The board can only decide procedural constitutional issues.
Good. I like that.
Right.
Okay. So James, I think we addressed your things, but at the end, come back if we haven't. So, whoops, did I just do that? I did. Okay. Okay, so these, as I recall, Jeff, are kind of the elements of a successful preliminary injunction. Would you like to review them for us?
Sure. So as we know, the preliminary injunction is a form of equitable relief. And as such, you have to run it through the 4-part test, and you're balancing, or the federal district judge is balancing the equities, and the equities are likelihood of success on the merit, likely to suffer irreparable harm, but for the granting of the relief, the injunctive relief, balance of the equities that tips in the applicant's favor, and whether the injunction is in the public interest. The preliminary injunction obviously is not a final ruling on the merits. It's just to enable the status quo to be maintained pending a final resolution.
Okay, so what does let's say Lavinia's got a case where they picked her up, and you want to also file a restraining order, a preliminary injunction to prevent her removal. What would be the likelihood? How would you argue likelihood of success on the merits? You're not talking about the underlying merits of her claim, right? You're talking about you think the judge will find in your favor.
Well, there's a case that goes into a lot of detail about the stay factors that everybody should read if they're thinking about doing this. It's called Nken versus Holder, NKEN versus Holder, and it's 556 US 418 2009. And so basically the court, Justice Kennedy in that case, goes through in very great detail and talks about what each one of these factors means, and whether or not the applicant for stay would be able to meet those requirements. What I would say is, the problem is it's not so much the likelihood of success in the merits, although that's a very important issue. But what you want to argue is that obviously if the person is deported, they would suffer irreparable harm. And there was an issue. The government in the Nken case tried to argue that, well, it's not really a big deal because we have procedures in place to bring people back once they've been physically deported. And they actually represented or misrepresented to the Supreme Court that those procedures were in place. They later filed a letter, the Solicitor General filed a letter with the Supreme Court explaining that that wasn't exactly true. But they do have some procedures in place now, and I've been successful in getting people back, paroled back in. But at any rate, it's going to be very, very difficult to pursue your case if the person was physically deported, and then you're trying to bring them back. How do you communicate with them? Is there going to be a delay? Are they going to be able to have access to counsel? And so definitely the likelihood to suffer irreparable harm is going to be, I think, one of the most important factors. And then the balance of the equities would tip in the applicant's favor.
It seems like in this area, if they're trying to do this to a VAWA or a UBs, you have some pretty strong equities and public interest arguments.
And on this point,
correct.
you can also use country conditions as well to demonstrate that the person would be subject to potential harm if there's any type of asylum or withholding claim or a natural disaster that has taken place. On one other note on this, in one case where we won at the Seventh Circuit and we were back at the immigration court, that you need to be aware of is ICE will often claim that your client's presence is not necessary and that they can set up a Skype through one of the consulates abroad and your client can go testify there. So if you have experience with the local ICE office that it's really hard to get your client to be allowed to come back to the US, you may want to put that in the request as well, saying irreparable harm. There was foot dragging in another case not too long ago that I was involved in, where I, did not bring the person back in a timely fashion. And irreparable harm, the longer that they're away from their family or their psychiatry appointments or other therapy in the context of a U or a VAWA can also be helpful.
Right. Right. And we can, again, this is very much the beginning, and we're just now trying to take all these concepts and apply them to VAWA and U visas, which is why you'll see many of the samples are not actually specifically U or VAWA. But it seems like this is an area we could be really creative based on their own memos and the intent of Congress. And the fact that ICE says they can pursue their cases abroad doesn't mean them doing that doesn't undermine their own guidance and what Congress intended. Okay, so we discussed a little bit how this is related to habeas. It sounds like, from what I understand, is that there may be many situations where you're going to file a habeas and file a restraining order at the same time, but they're really two separate documents. Is that correct?
That's correct. And in the sample that I provided, that relates to a motion for TRO/preliminary injunction, and also the memorandum of law, you'll see that distinction and how we argued it in that case.
Great. All right, so now her U is denied, and now we're getting to challenging the government's failure to implement or interpret the law correctly. So this is beyond stopping removal and getting them to make a decision. And this is the brave new territory because basically we have failed in getting CIS to fix the problematic ways it's been implementing the law or failing to even address the law. So Lavinia's been denied, and they denied it based on her waiver for whatever, and they only cited the D3 Haranka factors, or as most of you have seen, they'll mainly cite them and say, and plus you can do these other things that are D14, but they aren't specially designed for D14. So even this raises two issues here, because that to me is a legal problem, but then they also are exercising, as many of you have probably seen, exercising their discretion in ways to deny waivers that would not, in my view, would not be allowed by an immigration judge in immigration court. Or it seems like it's a inaccurate weighing of the factors. Let's say it was just disorderly conduct and it's not a conviction, and as you know, they may have, and it was later dropped, but still they use that to deny. So you guys, do you think this is the kind of thing you could challenge in federal court? And before we talk about what you may need to do first, well, I'll tell you what I think you may need to do first. You probably have to go to the AAO, right? If you're going to challenge this, right? And either get them to say this is not something we can do, or basically ignore your arguments, which is what we're seeing in a bunch of cases we've taken to the AAO on these issues. Assuming you've done that, can you take this to the federal court? And what would be the form for that? And how would you get them to take jurisdiction over your arguments?
I mean, I think that the answer is really going to turn on whether it's a discretionary decision or a is something that's a clear legal right, and it's something that is a legal issue as opposed to discretion. So right. as you have up here, the APA would probably be the best basis, because it relates to, as we put up here, 702, suffering legal wrong due to an agency action. Or being adversely affected by the agency action, and then we would argue arbitrary and capriciousness under 706, or unconstitutional or contrary to the INA. So you have to frame your discretion in terms of you know, you have to frame the issue in not in terms of discretion, but in terms of the failure to follow the legal structure or the legal statute or the regulation or the policy in the correct way. And it's a matter of statutory construction, not, you know,
Right.
the matter of discretion.
Right.
Yeah.
So let me tell you how we've been suggesting those of you out here who are trying to work this through the CIS system, you set this up for going to federal court. If you haven't seen the you need to implement D14 or you're violating the law arguments that we're asking you all to use, I would highly recommend you start including those in all of your replies to RFEs and your motions and your appeals to the AAO, because even if what really the problem is the way they're exercising their discretion, I think the way we get our foot in the court is they're completely failing to implement a law Congress passed. They've precluded any kind of review in their own system. So district court, we have to come to you to challenge the fact that they're not implementing a law Congress intended. And by the way, the fact that it's a discretionary waiver doesn't mean you don't have jurisdiction, because if they implemented the D14 waiver, instead of relying on D3, the discretionary decision would have been different. What do you think of that argument?
I think that sounds like what I'm saying, which is
Okay.
basing the you're going to frame the complaint in terms of a failure to follow a statute, as opposed to I just don't like how the adjudicator weighed the factors. See the difference?
Yes, but you could also, once you do that, you could expose their wacky ways that they're adjudicating factors, because that, I mean, even though it may not be a legal argument, it might motivate the judge to do something about it, right?
Well, I would also argue that if you're weighing the factors in such a arbitrary and capricious way, then
Yeah.
that is a legal violation.
Oh, good. I like that. Okay.
I mean, that's the thing. Other thing I would say is the $500 fee. I know that we talked about this with Maria. I think that is jurisdiction specific. So for me in the Southern District of Texas, SD Texas, it's $400. I just looked it up, and so I know that there are different filing fees and administrative fees determined by the circuit and the individual court.
And the third piece in Lavinia's case, which is common to all U visas, and I wonder if this would be just a separate lawsuit on the APA, is the regulations that preclude review. Is there an APA due process argument that precluding review of the discretionary aspect of waivers violates the APA or due process, especially since it's purely regulatory?
Well, the problem is, you're saying that the regulations preclude review, or the statute? The regulations?
Right. It's only so the statute doesn't say anything about review. The regulations allow review of U adjustment discretion denials, but they preclude review of U waiver discretion denials, which is why we've really run into problems, because they just go wild with their discretion.
Right. Well, discretion is a very difficult thing to get review of, as you know. And so it is true that generally speaking, the federal courts will not have jurisdiction over discretionary decisions. Again, I think that you would be able to challenge it. Now, Maria was talking about ultra vires. And so if you think, and I think that's a very good point that she was making, that if you think that the way that the agency is implementing the statute with respect to its regulatory scheme is ultra vires of congressional intent and the plain language of the statute, that's a different matter. That's a legal issue. So I would argue ultra vires.
I like that. Okay, so that's going to be one of the arguments we need to develop, Field. If any of you want to help, let me know. Thank you.
The other thing that I would just throw in is if the agency doesn't enumerate that it went through each of the factors to be considered and actually applied it toward the evidence, that the agency didn't, its decision on denying discretion is arbitrary and capricious because it didn't follow its own factors as laid out in the case law or in the regulations. And that gets you your legal issue.
That's good. That's good. So that you're not arguing it's how they exercise. It's not the discretion itself. It's that they failed to follow their own rules about how they should exercise discretion.
Correct.
Correct.
And a lot of the circuits have started to go that way on petitions for review. So the circuit language is helpful from
Great.
decisions involving like 212H decisions where the board fails to follow its own case law and to evaluate each factor in the evidence in front of it.
All right, that's really helpful. Great, thank you. Okay, and we kind of covered this a bunch of times, but we thought it was important to keep coming back to this because this seems like this is like the fundamental basis for all of the court's jurisdiction. Is that what, am I getting that right? And am I missing any other main points you want to make about the federal question statute?
I think you've covered it.
I think we covered that. Yes, yes.
Great. Okay, so let's quickly apply this to, let's say we're going to file this APA. And so one thing, I don't know if this is on this slide, what's the difference, if there is a difference, between an APA claim and a request for a declaratory judgment?
Well, the Declaratory Judgment Act provides that the federal court can determine the rights of parties, and so the problem with declaratory judgment, it's a separate thing.
Mm-hmm.
But the problem with it is declaratory judgment doesn't give any jurisdictional bases for the filing of the complaint. So you need something else, and that's why 1331 is so important.
Okay.
Similarly, the Administrative Procedures Act doesn't really give jurisdictional, although you can argue that it's part and parcel of the jurisdiction because it is a federal statute. But the courts have been very clear that you need to allege 1331 in addition to APA, in addition to declaratory judgment, etc.
So that's why this is so important. This is how you get your foot in the door for them to even look at the other things you're arguing, because this is where we're actually asking the judges to change the way the government's implementing the law, right?
Correct. Yes.
Okay. So the parties would these just be these federal parties that you've been talking about in other contexts? You don't need to do wardens and all that kind of thing for this, do you?
Well, again, it depends on how you're framing the complaint. If it's a claim that relates to a habeas case and you're bringing it in addition to the habeas challenge, then yes,
okay.
you might need to do the warden. If you're bringing a case based on your hypo, where it's like after an AAO decision and the person's not detained, then you have to look at, who the adjudicator is. And, for example, when it comes to service centers, you might have to include the director of the service center or the local USCIS office or the district director, et cetera.
And that seems related to me to venue, right? Because it's the one situation, maybe there's more, but the one situation where you really have the venue focuses on where your client is habeas. But it seems like what you're saying is in other challenges, like with mandamus and with these kinds of challenge on how they're applying the law, venue could actually be where the agency is that's making the decision, right? It's Vermont, for instance.
I think that's right.
Okay.
Yeah.
And is there any other, and I think we've covered most of the jurisdiction bases. Is there any additional jurisdiction bases besides, it seems like we keep adding on more jurisdiction bases as we move forward?
No, I don't have any unless Maria has some.
Okay, and same question on the sources of law. I think they're very similar basically here, jurisdiction and sources of law, right?
I mean, I guess for sources of law, I mean, there are different, if you look at Bob Powell's book, so if you really get into this, I mean, you can read Bob Powell's book, Robert Powell, P-A-U-W, Litigating Immigration Cases. I just got the 4th edition. I think it's the 4th edition. Yeah. But anyway, there's a lot more. So you could, as far as sources of law, I mean, you can bring cases in federal court under the Federal Tort Claims Act, which again probably is beyond the scope of this webinar. But there's other sources of law that we could talk about, obviously. But I guess I would refer you to, the treatise on this subject, which is Bob Powell's book or Ira's book.
Oh, Ira has the Kurzban, right?
Yeah, he has a whole section on federal judicial review.
That's great. So I'm just putting both of these here. So what about the request for relief? Anything new that we haven't discussed already?
Well, declaratory judgment, right? So you mentioned Declaratory Judgment Act, and you can ask for a declaratory judgment that spells out and delineates the rights of the parties and the way that the case should proceed from that point on, and the court has a jurisdiction to make that ruling.
And you can proffer, I mean, because I know this because we're actually preparing this now for the work authorization bona fide litigation. You can actually proffer a definition of the law that you want them to adopt, right? So you don't just have to say, you decide, Your Honor, what the law should say. You say, here's what we think the law Congress meant when they created like the bona fide phrase.
Well, some federal judges that I've seen will actually ask the parties for a draft declaratory judgment.
And so that's what you can ask them to declare, for instance, that bona fide means blah, 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 blah.
Yeah, I mean, that's the beauty of a declaratory judgment, that you can try to get that level of specificity.
That's excellent. I like that. Okay. So I've already started incorporating things we want to challenge, just so you know. This is, and we're hoping actually eventually to be able to hire a consultant who can coordinate our litigation training and work. So if you're interested in that, let me know. Will not be full time right now, but I can't keep doing this. So what we are actually actively pursuing and trying to find help to pursue is forcing ICE to follow its own memos and using their failure to do it and using their failure to follow them as Congress intended or as even the agency intended as the basis for getting other decision makers to stop removal and maybe even get your clients out of proceeding. The things we've just been talking about in terms of APA and declaratory judgment is the failure to implement the bona fide, as we discussed, the failure to implement the D14 waiver, and as we also discussed, this idea of challenging the lack of independent waiver review as ultra vires, as a statutory challenge, because the statute, or ultra vires of the statute, because the statute doesn't include it. Let me ask you two, and then anyone else in here, are there other issues that the substance of which we, in this area, you think we need to litigate now? Because assume that we are not going to be able to fix anything through advocacy or legislation for the next 4 years. This and grassroots organizing are probably going to be the tools we need to use for changing how they implement the law. Any other thoughts?
I mean, I'll just say, Gail, that you're the VAWA, U visa, T visa expert. So I think that, you would be the best person to talk about the substantive issues. So I'll just say I've always come to you in the past, 10 or 15 years if I've had questions on those issues. And then I think that obviously you can inform the federal litigation by identifying those for the litigation team.
Okay, and so that's back at all of you who are listening too, because we have to focus on like the top 3 things always, but I'm sure there are lots of other issues that could be litigated, like the one we tried to do, Maria, that LPR should be able to apply for U visas, right? That just are never going to get to the top of the pile, but we hope that the skills you're learning through this and in the next few years will enable you to help us litigate all the issues we need to litigate, because we're not going to be able to coordinate all of it. So definitely let me know in particular for now, until I can hire a consultant, what those issues are that we haven't identified so far.
And one thing I'd like to just throw out there too is for anyone who's on the call that's an AILA member, the federal court litigation section has a good discussion on the federal litigation court listserv. And so, Gail, you've coordinated with a lot of AILA attorneys in the last couple of years on federal litigation. So the membership on the federal court litigation section is free for AILA members, and you can get signed up.
Oh, I didn't realize that. Yeah, we're going to actually try to set up a call for them, as well as people at the litigation meeting a couple of weeks ago. So, and again, any of you want to get folded into kind of the national litigation coordination on using VAWAs, let me know. Stephanie just shared one, which I think I sent back all of you. I agree. Stephanie does a lot of the T visa stuff. This whole on account of trafficking thing is like, it seems like they're using it as a loophole to deny a vast majority of T visas. And I agree with you completely. That's something we should set up for review by a federal court. All right, now let's get back to you can actually get your money back if you do this and win, right? So let's get back to the EJA fees, Equal Access to Justice Act. So tell us, I think, Maria, were you going to cover this for us?
I think I was, but.
Okay, that's great. So jump in, Maria. I think I probably skipped you doing something else. Sorry about that.
That's all right. I'll jump in. Jeff, take it away.
Go ahead. Go ahead. Feel free. Oh, you jump in, meaning I'll do it. Okay.
Yeah,
So EJA fees, yes. So EJA fees are available, but there are a lot of hoops to jump through. So I want to make sure that people, well, number one, the first point is people should be applying for EJA fees and include this in the complaint as one of the prayers for relief. But just understand that there are a lot of hoops to jump through, and I've been successful, especially when I was in Miami, with getting EJA fees, but it wasn't easy. So the first point is the petitioner has to be the prevailing party, and that's a very specific definition. We can go back to what that means. The other requirement is that, I don't know if we have this in the slide, but we should, that the person, there has to be an allegation that you make in your motion for EJA fees that the position on the part of the government was not substantially justified. Oh, yeah, we do have it. Okay. There has to be no special circumstances that would make an award unjust for some reason. And then there has to be a showing that the petitioner has met the appropriate net worth requirements. Although that's never going to be an issue because net worth is like $2 million.
Oh, yeah.
So I don't think any of our clients.
For this crowd, I don't think. Yeah.
No problem. Yeah, I don't think our clients have that problem. But let me just talk a little bit about the definition of prevailing party status. And the definition is a prevailing party is one who has been awarded some relief by the court, and as our slide says, judicially sanctioned material alteration of the legal relationships between the parties. So that's pretty wide open-ended. And whether a remand counts depends on the jurisdiction. So again, there's a split in the circuits on how they're going to determine prevailing party status. The other interesting thing is about substantial justification, and I don't remember if we have a slide on this.
We do.
Yeah, we do. The government bears the burden of proving it. There may not be substantial justification if the position diverges from the IJ's or BIA's rationale, for example. So if you're in front of the federal judge and they're making some argument that's not based on their client, or the agency, I should say, then that could be a lack of substantial justification. If they ignore a split in the circuits or it's contrary to authority that they've actually stated in their own briefs, that's also a red flag that it may not be substantially justified. But I'll just say this: the burden of proof is on the government. So once you establish that you're the prevailing party, then the government can only avoid payment of the fees only if it can show that its pre-litigation conduct and litigation position were substantially justified. So it's like a burden shifting, but you have to at least allege it in your motion. And then, I guess the other thing I would say is, I think Maria already kind of mentioned this, but the court is going to be very, very suspicious. I know suspicious is the wrong word, but very, very closely monitoring your assertion of your reasonable fees. So, unless you can establish that you have a special factor that would merit enhanced fees. Oh, that's the next slide. A prevailing party must show reasonable fees. There's a statute fees because immigration law is complex. We all know that. The party files a motion with a breakdown of the fees. The government will usually object. But again, you're going to have to prove that there's some reason that you should get enhanced fees. So usually it's the statutory rate. I think it's 125, if I remember correctly. Yeah, 125 for cases commenced after 1996, but it can be adjusted or enhanced. And then just be aware, this is really, really important about the deadline. It must be requested within 30 days after the appeal period runs. So if it's a court of appeals to the Supreme Court, then that's a 90-day period. But if it's a district court and you're filing against the government, then it's the 60 days, right? It's 60 days to file the appeal. And so be very careful that, you know, you really should file it as soon as you can, so you don't run up against those filing deadlines. And the filing deadline, you know, may be pretty quick, depending on where it's located, circuit court, district court, or on a petition for rehearing, et cetera.
And I think this goes back to what both you were saying when we first addressed this, is that it behooves you to start right away with tracking this, so you're not trying to catch up later on once you realize you might win and request each of these.
And also track your copies, because where you have to file the paper copies, the copy costs can run up to be quite a bit.
Oh, that's so that's where the costs come in, right? So when you talk about, so obviously time is one of the things. What else can you, is it a difference between the EJA and other costs? Or is that all part of the EJA request?
It's all part of the EJA request. So you can request the filing feedback, you can request copies for a briefing. You can also include Lexis or Westlaw charges on it. And then one other point about enhanced fees. So you start with the statutory minimum 125%, and then there's actually a chart available online for inflation increases per region. And that's helpful to try to boost your rate up to like 175, 185 approximately. And if you want to go for enhanced fees based on the skill level needed to pursue the petition, you definitely want to consult with other practitioners in your area. It's very hard to, I think, get enhanced fees based on skill level for a mandamus unless there are complicated legal issues involved in a mandamus. Habeas, you may be able to get enhanced fees over 200 more easily. For enhanced fees, you do need letters of recommendation from other attorneys in the area about why your skill set is so outstanding that you were the attorney that it needed to be, as well as the number of nonprofits that are available to handle it at no cost or low cost. So it gets a little more complicated for enhanced fees, but the inflationary enhancement is easy to get.
And yeah, we can... I agree. Let me just say that law clerks, paralegals, and expert witnesses, they can also be compensated under EJA as well. So don't forget paralegals. Yeah.
And the fact that I don't get paid anything near 125 an hour doesn't matter, right? It's the statutory rate.
Correct. I mean, even pro bono or nonprofits. There's a case, I believe, Supreme Court case that says that nonprofits can also recover under EJA. They don't even have to be billing or you know, expecting a paycheck at the end of the day.
That's very helpful, since I imagine a lot of these folks either are nonprofits or don't make $125 an hour. So that's an important thing to know.
So one other thing here for the nonprofits, it's important that if you are going to go after EJA fees, that you've got a very explicit representation agreement in place, or whatever your state bar happens to call it, because otherwise, if you're expecting to get paid under EJA, the money goes back to the plaintiff. It doesn't go to you.
So is that when you say an explicit, this is like in the contract between you and your client, it has a clause about the attorney will get the EJA fees, or the agency will get the EJA fees?
Or that the plaintiff, the client, will sign over the EJA fees to the attorney, whatever is required under your state bar.
All right. So that sounds like we need that as a sample too.
That's a great point, and I remember reading it when I first read this practice advisory. I think it's called assignment. You're assigning the EJA fees to the attorney, and I'm pretty sure that it's discussed in the practice advisory. I just don't know where, but it is in there. Great point.
All right, so now let's move on to, like, what are they going to do now, assuming that they haven't gone through all that admitting to their local court. It's like one of the things that, if you're, because I know a lot of the folks here have clients who actually might have to file in some other district if they had to file. It sounds like now is the time to be making those connections with lawyers in other districts where they're likely to have to file, or maybe even in their own district. Can you do a pro hoc vice in your own district if you haven't been admitted yet?
Yes.
Okay. Okay.
You can do pro hac vice even if you're not admitted in that court and you're let's say you're barred in the state. That's correct. I mean, I did a pro hac vice in Dallas, in the district court in Dallas. And I'm not admitted in, I'm admitted in the Southern District of Texas, but not in the Northern District.
Okay. And does that mean if you were eventually to go forward with that case and it doesn't get thrown out of court that you would still have to get admitted, or could you do pro hac vice the whole way through?
No, pro hac vice means for the pendency of the case. In other words, you're an attorney admitted for that case. That's my understanding.
Okay. But it does seem like, so it means that you wouldn't necessarily have to go through getting admitted in that other district court if it's like you're only going to go there once or something. But it does, correct. I think one thing I have learned is you do not want to be springing this on possible pro hac vice attorneys at the last minute. That you definitely need to line up people now in the places where you're likely to need to appear, so that because they're signing their name to it, right? So they're called local counsel. They're not. Yeah. You're the pro hac vice. Oh, okay, got it. All right, got it.
Yeah, you're right. You want to set up. You want to have friends of yours that hopefully you have friends in that jurisdiction that could just enter an appearance for you, and then you'll be going to court. So it's a pain because then you got to drive to wherever the actual hearing is. Or, unless the local counsel wants to do it for you, but, generally you're going to be having to go to court wherever that court is located. Okay.
So in the last few minutes, we just wanted to kind of come back to focusing on what are your next steps besides learning the law, the federal court law. We've discussed, I think one of the key things is going to be finding, experienced litigators in the area, your area, or wherever your clients are going to have to file. And we would like to work with you on that. And so 2 things. One, if you are an experienced litigator listening to this, or other experienced litigators who'd be willing to take this kind of training and mentor people locally, or allow those of you who aren't litigators to shadow them, we need to start that networking now. Because this is going to be a long-term project, and rather than have you guys figure this out individually, let's see if there's a way we can do it collaboratively. So let us know if you're a litigator and are willing to participate in that, or make some connections with your local litigators who are friendly, especially if they've done a little bit of U visa or VAWA, and see if they'd be willing to play this role. We are starting to do templates. We've got stay templates. We need to obviously develop some U and VAWA based versions of the templates that you have in there, but you'll see what you see in your materials is all this creative stuff that people have been trying so far. So as you work it out, or as you're thinking it out and you want to share that kind of thing, either with a small group or with the field generally, please send it to me and I will share it. We'll redact them for you. What we've learned in the stay area, which I think is probably especially true in the habeas area, is that for clients who are most vulnerable, you may want to practice now on drafting some of this stuff. It sounds to me like a lot of the things about jurisdiction and venue and parties are going to be pretty much you could cut and paste and just make sure you, like with the parties, you're including everyone, you've got them in the right order. So I think you could practice doing that. And then the key thing you're probably going to need more practice on is the different kinds of legal foundation for the judge for what you're arguing and what you're asking them to do. And then one of these things, I think, Maria, this last one is something you had raised at one of our advanced U trainings, that one of the key pieces that you need to do, even if you are already admitted, is figure out the emergency situation, right? And that's going to be different with every district as well.
It is. And when in certain districts, when you do the online filing, you can flag whether it's emergency or not. But I know from the explosion of habeases that were being filed the weekend of the first travel ban, there are processes now in place. So especially in some of the more remote districts. So it would be helpful to coordinate the list, Gail, I think, from the different airports and processes that were developed over that weekend. For the 7th Circuit Court of Appeals, each Circuit Court of Appeals is also different on stays. and you need to figure that out. So often what I will do is if I know I'm going to be filing a stay after 5 o'clock that night and my client's set to be on the 9 o'clock flight on a Friday morning to Mexico, I will call the circuit clerk and ask to speak to the attorney in charge of stays, the staff attorney who's a permanent position, and say, hey, I'm going to be filing this. It's going to come in after 5. And then the supervisor will contact the emergency judge who's on for that night. And at 6 o'clock in the morning, they will look at the stay application or the stay motion and then decide it very quickly and communicate to ICE. So if you're in a place where bodies get moved, clients get moved very quickly, and you've got a routine scheduled flight departure time, you want to make sure you give a heads up to the district court or the circuit court staff attorney before you file.
Okay, that's great. And we really are at the end of our time. I think we at least addressed most of your questions. If we didn't, and I see Kathleen, you have a new one. Why don't you send your question to me? And Maria and Jeff have very kindly said they'd be willing to talk to you as well, but I'll do the triage and bring them in to help out with the answers to any of the questions we weren't able to answer today. So thank you very much, Jeff and Maria. This has been, I've learned a lot. I hope all of you listening learned a lot. This is just the beginning, so don't feel frustrated if it feels like a lot of it went over your head. As you can hear from me, it's taking me a while to learn it. So, but hopefully 3 years from now, many of us will now be able to do this kind of work and use this as one of our tools for helping survivors of violence.
Thank you.
Thanks, everyone. Bye-bye.